Welcome once again to Lehto's Law. Here's Steve Lehto.
I had a whole bunch of people send me this story, including Steven with a PH, and he sent me a link. It said, Steve, check the version out in Reason.com. And Reason.com did a very good write-up of this. Tennessee Appeals Court rules against wildlife agents who planted cameras on private land. And the Institute for Justice was involved in this one also. It was a unanimous ruling from a three-judge panel that while the state law that the people say they're enforcing is constitutional, the way the agents were handling it was not. And this, of course, would be a very serious problem. Someone comes onto your property without a warrant, plants a camera without your permission, and leaves. Then comes back later and grabs the camera and then uses whatever they find in that camera against you. And as I've said so many times before, why not get a warrant? Are you telling me that that camera's got to get planted today, right now, so fast, you haven't got time to go get a warrant to plant the camera? Seriously. So Joe Lancaster wrote this for Reason.com, and back in December of 22, Reason reported that both state and federal wildlife agents routinely trespass onto private land and plant cameras. 2 Tennessee homeowners successfully sued the state over the practice, and a 3-judge panel ruled in their favor. The state appealed that decision, and this week the Court of Appeals also ruled in their favor. And I had somebody send me a nasty note last time I talked about this and go, Steve, you apparently don't understand how many people break the law with respect to wildlife and hunting. Who said that? Yeah, no, there's people out there who break all kinds of laws. And there's rules that law enforcement must follow to go after these scofflaws. And so you might need to get a warrant before you go onto private property and plant a camera. I'm not saying that they shouldn't be allowed to enforce the laws. I'm saying they should follow the laws that talk about how they enforce the law. At issue is a state law that allows officers of the Tennessee Wildlife Resource Agency to go upon any property outside of buildings, posted or otherwise, in order to enforce all laws relating to wildlife. In the case of these 2 homeowners, TWRA officers not only entered their respective properties, but also installed trail cameras to look for hunting violations without a warrant and ignoring all the no trespassing signs. A lawsuit filed by the Institute for Justice on behalf of these 2 asked the court to declare the law unconstitutional and issue an injunction against the TWRA, barring it from carrying out any further unwarranted intrusions. So as noted, the court did not find that law unconstitutional, but said that it was in fact being applied inappropriately. Now, the Supreme Court created a thing called the Open Fields Doctrine, which goes back to the Prohibition days, and holds that undeveloped land on your property lacks the same rigorous Fourth Amendment protections as the home and the curtilage of the home. So the home itself, protected. The curtilage immediately around it, you know, like, I don't know, the porch, an attached garage, those things are protected. But outside in the open fields, no protection. So in March of 2022, a 3-judge panel from the Benton County Circuit Court ruled in the homeowner's favor, finding that the state constitution provided more protections than the Constitution's Fourth Amendment. It determined that the state law allowing the TWRA practice created an intolerable risk of abuse and was facially unconstitutional, but they stopped short of issuing the injunction that IJ asked for. The state appealed the decision on the following month. In a hearing before the Tennessee Court of Appeals, Western Section, on June 20th of last year, IJ attorney Josh Wyndham, who I've met, by the way, nice guy, argued that the state law is unconstitutionally broad. It allows TWRA officers to enter and roam around private land, fishing for evidence of crime, he said. It doesn't require consent, doesn't require warrants, it doesn't require probable cause. It's a blank check for officers to invade private land whenever and however they please. Now, an attorney argued for the Tennessee Attorney General's office that the statute was not unconstitutional and that the policy was necessary for the TWRA to do its job. She argued that it's the particular purpose and function of the TWRA which makes such warrantless entry reasonable. And a judge asked her why, if the state would need a warrant in order to enter someone's property to look for criminal violations, it should not also need a warrant to do the same for civil violations of hunting laws. She agreed that while normal law enforcement officers would not be able to enter without a warrant, you have to look at the state's interest in furthering its duty of protecting and preserving Tennessee's wildlife. But the judge pressed further, asking whether the state has an even stronger interest in protecting persons than wildlife. He also asked, if you can't enter to investigate a crime being committed against a person, why is the interest greater to enter to protect wildlife? Man has a point. Good thing he's a judge. In a decision issued Thursday, the Court of Appeals ruled in favor of the property owners. TWRA claimed that the homeowners' claims of injury were speculative, as TWRA agents have not entered the lands since September 2018, but the court disagreed. The unanimous opinion says, even if the TWRA has not entered the plaintiff's property since 2018, it continues its power to do so. The TWRA has asserted a continuing right to enter upon the plaintiff's properties. At oral argument, the TWRA suggested that if the plaintiffs want to keep these people off their land in the future, they should desist in hunting. But if you stop hunting, which is your right to do, number one, how would they know you've stopped without planting cameras to confirm it? At the most foundational level, the court said, the statute is facially constitutional because there are applications of the statute that are permissible, including wild wasteland areas. But in this specific scenario, where wildlife agents planted cameras on homeowners' land without ever even pursuing a warrant, the court found the TWRA's actions unconstitutional as applied. The TWRA's contention is a disturbing assertion of power on behalf of the government that stands contrary to the foundation of the search protections against arbitrary governmental intrusions in the American legal tradition, generally, and in Tennessee specifically, the court wrote. What the TWRA claims is reasonable is not. Our entire theory of the case was vindicated by its decision, the IJ attorney told Reason. The part that goes against the trial court ruling says that the statute can be constitutionally applied to land where people haven't taken any steps to exert control or exert their privacy, which is a rule we don't particularly object to. So if you owned land, you didn't fence it, it wasn't posted no trespassing, it's just land out there. And maybe there's not even anybody living on that land. Well, obviously, the court's saying, well, they can enter that land and maybe plant cameras or whatnot. But land that people live on and it's fenced and posted, yeah, that's a problem. And so getting back to this is one of my things, okay? When I'm reading these stories about the police or the government saying we'd like to do this and keep doing it without getting any warrants. We just need to be able to do this stuff because we don't want to get warrants. And the question I'd always have as a judge, the first question I'd ask is, why not? Why wouldn't you at least try to get a warrant? There's nothing that's going to disappear in the couple hours it takes to get a warrant here, is there? Like, was there a hurry? Was there a rush? And they're going to say, no, we were just going to go out there and plant cameras and come back in a month and pick them up. Okay, so spend half a day, get the warrant, then go plant the cameras. And you and I both know why the answer to that is we don't want to do that. And that's because they don't have actual probable cause. They are, forgive the bad pun, but they're fishing. They're fishing. They're hoping they catch something. They're hoping they catch something. But they don't have any evidence of it, do they? Because if they did, they could go get a warrant. And it seems so painfully obvious, but quite often you don't see it brought up that much. And like I said, it's to me, that would be the first question. Why can't you get a warrant? And there are circumstances where you don't have time to get a warrant because something's happening, unfolding immediately. And we're talking about somebody hunting on a piece of property, perhaps out of season or for the wrong things. Really, you don't have a couple hours to go get the warrant. Oh, you haven't got the actual probable cause to get the warrant. That's the problem. Oh, now it makes sense. And that explains why this was wrong. Why they had to go to court on this, what they were doing. And so the court came down the right way. I have not read the entire statute, so I don't know if it's something that should have been ruled unconstitutional on its face. But the court's clearly saying that you guys can't enforce that law this way. And so got to point out Reason.com because they've been all over these cases, all these privacy cases. Joe Lancaster wrote this story and did a great job of it. But I've also got to mention the Institute for Justice, They do great work, and they help people like this. Because if you wanted to take this case to trial and you won, you'd have to pay an attorney. Then, when it goes up on appeal, it costs more money. And you never know. The TWRA might appeal this to Tennessee Supreme Court. They might. And that's even more money. And the average person can't afford to litigate something like that on their own. And so the Institute for Justice is supported by the generosity of people who just donate to them and say, I like the work they do. I'm going to support them. So I put a link to them in the description below every video I do where I mention them, or at least I try to. And I'd recommend that you take a look at the work they do. Even if you can't support them financially, you can support them morally, where you just simply give them moral support and visit their webpage, sign up for their newsletter, and just follow what they do. Because one of the things they're doing here, they're not just helping these two guys. They're trying to create case law that will help everybody who could be in the position of these two guys. And they're also trying to get word out about the problems with the legal system, problems with law enforcement, problems with constitutional violations. And so some of this, what they're doing is legitimately just trying to call attention to things. And so I did a story recently about how the Supreme Court touched on civil asset forfeiture recently, but decided not to overturn it just yet, but hinted they might in the future. And oh, you better believe the Institute for Justice is all over that. In fact, I got an email yesterday from them talking about the fact that they saw that. They caught that. And, it wasn't lost on them that one of the justices said, we might revisit this if it's framed properly and brought before us. And the interesting thing is that 10 years ago, if you ask the average person what civil asset forfeiture is, they'd go, what? Civil what? And now a lot of people know about it because people like the Institute for Justice and Reason.com and me and other people on the internet are screaming and yelling about it because we want everyone to know. And the more people that know about it somehow makes it more important for the courts to take a harder look at it. So it very well could be that these laws could change. And one of the driving forces there will be what we call the groundswell of support to overturn something. So again, check out the Institute for Justice, check out their website, check out their newsletters. And Stephen and everybody else who sent this to me, thank you very much. But Tennessee Appeals Court rules against the wildlife agents who planted cameras on private land without a warrant. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law.
Every path has a few puddles.